Now, former Ugenya Member of Parliament David Ochieng has moved to court to challenge the newly gazetted election laws. Ochieng claims some provisions of the law are unconstitutional. A gazette notice for the controversial election laws was issued yesterday, and thus the law took effect immediately. This is after President Uhuru Kenyatta failed to sign his assent for the law within 14 days. Let's now take a look at some of the specific clauses of this law that have been termed as controversial, one of them being Section 39 of the Election Act 2011. Some of the amendments that have been made. The commission, which is the Independent Electoral and Boundaries Commission, shall from now onwards verify that the results transmitted during an election are accurate, and record of the results tallied, verified and declared at respective polling stations. Then after that, any failure to transmit or publish the election results in an electronic format shall not invalidate the result as announced, and this specifically coming at a time when the Supreme Court of Kenya annulled the election on the basis of inconsistencies with procedure. So some parts of this law trying to seal that loophole that was there as they have described it. This particular act also says the Commission shall establish a mechanism for the live streaming of results as announced at polling stations, but shall not be the basis for a declaration by the Commission. The Commission will then take a look and proofread all the results that coming from polling stations before making an announcement, which is not necessarily consistent with what would have been live streamed for the basis of the public's information. Now, in Section 83 was deleted and substituted with a court shall not declare an election void for non-compliance with a written law relating to that election if it appears that, one, that particular election was conducted in accordance with the principles laid down in the Constitution, and two, the non-compliance did not substantially affect the result of the election. Once again, this particular law is emanating from that Supreme Court move to declare that particular election from August 8th as null and void. After Section 86, there has been another section that has been inserted there, being termed as Section 86A now. An eligible candidate for an election pursuant to Article 143 of the Constitution may withdraw from the election by notice in writing to the Commission. Remember, this brought about a lot of voices or a lot of controversy after Raila Odinga, the NASA leader, sought to withdraw from that particular race, but did not do it formally and did not sign a particular form that became a bone of contention. And when this happens, where there are more than two candidates remaining, candidates in the election after that particular withdrawal, the election shall proceed as scheduled. If there are not more than two candidates remaining and only one candidate remains after that withdrawal has been made, then the remaining candidate shall be declared elected forthwith as the president-elect without any election being held. These are some of the contentious clauses, so to speak, in that particular law, where the MP David Ochieng has taken to court seeking to declare unconstitutional, and of course the inconsistencies in how the procedure of elections should be conducted that consequently lead to the announcement of results.